We welcome our teams from India, from Kazakhstan at English Student League final of the JurAsia InterTax Moot Court. Let me introduce our teams. Team number one, our defendant today, is a team from Indian International University of Legal Education and Research. Team number 58, our claimant from Kazakhstan, from Kazakh National University named after Al-Farabi. Our panel of judges, let me introduce ourselves. Mr. Kees van Raad, chairman of the International Tax Center Leiden, advisor to Loyens and Loeff. Mr. Philip Baker, barrister practicing at Field Court Tax Chambers and visiting professor of international tax law at Oxford University. And my name is Ravil Kasilgov. I'm a partner at TKS Disputes. We are co-organizers of this moot court. Couple of words regarding the procedure. Each team will have 20 minutes to deliver. Then you will have up to 10 minutes for up to 3 questions to opposing team. And you will have a right to have a rebuttal for up to 3 minutes. And I encourage you to use that right. I'm asking my fellow arbitrators if they have anything to add. If yes, please. If no, then we're ready to start from claimant, team number 58, please.
Yeah. Good day, Your Honor, esteemed members of the court and counsel for the respondent. My name is Amina, and we're representing position of the claimant. So our position rests on 4 legal arguments that will prove our position. Let me shortly introduce all of them. Argument number 1, the premium is part of price, not interest. Argument number 2, SBS activities don't constitute a permanent establishment, means PE, of FPVT in Salak land. Argument number 3, the transaction between companies has only a commercial purpose. So let me start with argument number 1. The premium is part of price, not interest. The tax paradise land tax authorities maintain that the premium stipulated in a contract between SBS and FPVT companies cannot be viewed as interest, as it represents a change in the equipment price based on payment terms, but not debt obligation. According to Article 11, Paragraph 3 of the OECD Model Tax Convention, interest is defined as income from debt claims, which includes returns on government securities, bonds, or debentures. However, this definition doesn't cover a situation where a product's price varies due to different payment options, such as installment. In the case of SBS and FPVT, the price increased from 100 million euro to 115 million euros is directly related to the installment option rather than any other debt arrangements. This change in price doesn't constitute interest under the OECD Model Tax Convention, since there is no underlying debt claim that will generate any interest. In addition, by analogy, we can use the Civil Code of the Republic of Kazakhstan. For example, Article number 387. This article provides that obligation may be performed with deferred or installment payment, if so provided by the contract. In the case changing the price of equipment depending on the payment terms is a legitimate commercial practice that allows for a price changes depending on the timing of payments. This rule doesn't indicate the need of automatic interest if the parties have simply agreed to change the price of the good based on such kind of terms. For example, in the case of Bulk Allen Ltd and others versus Revenue and Customs Commissioners in UK to 2007, a double taxation situation was considered involving dividend income which was taxed both in UK and US, but the court held that double taxation should be avoided if taxes had already been paid in taxpayer's country of residence. So let's move to my second argument. SBS doesn't constitute permanent establishment PE for FPBT in Salakland, as it doesn't meet the fixed place of business criteria under Article 5 of OECD Model Tax Convention, Paragraph 1. Paragraph 4 of Article 5 states that the specific activities, even when carried out at a fixed place of business, they don't constitute PE if they are of preparatory or auxiliary character. If SBS activities mainly involve supporting services like sales assistant or client consulting for FPBT, this can be classified as auxiliary, thus not creating a permanent establishment. Paragraph 6 holds that if an agent acts within the usual scope of business on behalf of other, this doesn't constitute permanent establishment. Should SBS operate independently and enter into transaction with other entities, its function may be deemed independent rather than as dependent permanent establishment. From the problem, we see that the SBS company in 2022 entered in a contract with other oil refinery company after the contract with FPBT that shows they are operate independently. Paragraph 5 of Article 5 further specifies that a dependent agent PE is only established if the agent has the authority to conclude contracts on behalf of the principal. So if SBS merely promotes FPBT interests without contractual authority, it cannot be considered as permanent establishment. So let's move to my third argument. The transaction between companies has only a commercial purpose. The tax authorities of tax paradise land confirm that the transaction between FPBT and SBS was purely commercial and should be treated in a good faith and fair dealing in accordance with UNIJWA principles, especially principle 1.7 and 4.8. So Article 1.7 requires honesty and fairness in international commercial contracts, and this transaction was conducted under normal commercial terms and was transparent. Both parties, they negotiated in good faith based on their market conditions. But the Salakland tax authorities, by attempting to recharacterize the deferral premium as interest income, are violating principle of good faith. Their actions are motivated by desire to increase the tax base rather than reflecting to real economic substance of the transaction. So this constitutes an abuse of rights under Article 4.8 of UNIJWA principles, as the tax authorities of Salakland are using their power to unfairly impose taxes on what is essentially part of the equipment price. Let me give the floor to my colleague, Ms. Tolkanay.
So, good evening, honorable judges. My name is Tolkanay, and I'm representing the claimant side on this dispute. So, the first, and I will add some more information to contemplate and to define the Amina's point of view and our claimants defending strategy. The first argument is the fact that the premium is part of the sale price and not interest income. Firstly, we assert that the premium is part of the agreed purchase price for the equipment, not interest, under the Article 380 of the Civil Code of Republic of Kazakhstan. Parties are free to set the terms of the contract, including the price, through mutual agreement. Here, the parties agreed that the equipment would cost 100 million euros if paid upfront, for 115 million euros if paid in installments over 5 years. This premium of 50 million euros, therefore, a contractual adjustment to the sale price based on the different payment terms. Article 387 of the Civil Code of Kazakhstan, Civil Code of the Republic of Kazakhstan, similarly allows for different payments as part of the commercial transactions. It doesn't mandate that such adjustments be treated as interest unless explicitly stated in the contract. I think also it is important to note that in addition to defend the claimant side, we can also use the substance of a form doctrine, which states that we need to judge the transaction form, judging by its substance, nor their form. Further, under the Article 25 of DTAA, if one of the contracting states refuses to participate in the mutual agreement procedure, abbreviated as MAP, the taxpayer has right to request arbitration. Tax Paradise Land initiated the MAP process, but Salok Land declined to cooperate, violating the provisions of the agreement. This refusal not only undermines the taxpayers' rights, but also contradicts the principles of the multilateral instrument, which both countries have agreed to uphold. So my next argument will be the fact that the consistency with principles of the Islamic finance. Consequently, it is also crucial to highlight that SBS is undergoing through a transformation into a Sharia-compliant bank. Under Islamic finance principles, interest or riba is strictly prohibited. The premium in this transaction is a markup agreed upon in a Morabaha contract, not interest. Attempts by the Salok Land tax authorities to recharacterize the premium as interest is very ignorant to the religious principles of another country. So my next argument and also my last argument will be the fact that the STTR and the DTAA is misapplied and some rules from these agreements are violated. The tax authorities of Salok Land have applied the STTR incorrectly. According to the updated provisions of the double taxation avoidance agreement, or abbreviated as DTAA, between Tax Paradise Land and Salok Land, profits are taxable only in the country of residence unless a permanent establishment exists in the source country. FPBT does not have a permanent establishment in Salok Land. So, concluding everything, we ask that you affirm the rights of claimant FPBT to fair treatment under the terms of the DTAA and the multilateral instrument, ensuring that the tax obligations are assessed in good faith and in accordance with the established legal principles and in accordance with international law. So, I'm passing the word to my colleague, Islam.
Good day, Honorable Court, Counsel for the Respondent. My name is Islam, and I'm with my colleague, Ms. Rayatullah, who represent the Federal Republic of Tax Paradise Land in defining the tax residency status of GLUC AI. So the core issue in this dispute is the attempt by Salok Land's tax authorities to reclassify GLUC AI as a tax resident of Salok Land, solely because certain operational activities are supported by artificial intelligence hosted on servers located in Salok Land. However, this interpretation is both legally and factually flawed. So moving to the first argument, the use of AI does not alter tax residency. Under Article 4 of the OECD Model Tax Convention, the place of effective management is determining factor for tax residency. Place of effective management is defined as a location where key managerial decisions that affect the entire business are made. In this case, GLUC AI's strategic decisions, including those concerning operations, finance, and overall management, are made by its board of directors based in Tax Paradise Land. The use of AI to assist in operational process does not transfer the company's place of effective management to Salok Land. To support this argument, we refer to the tax code of the Republic of Kazakhstan. According to its Article 219, taxpayers are defined as individuals, such as citizens or residents, as well as legal entities registered in accordance with the law. These entities bear tax obligations, but AI lacks legal capacity and cannot assume tax liabilities. Despite its technological advancement, it is merely a tool that assists in decision-making, but does not replace the human board members who exercise ultimate control from Tax Paradise Land. In the context of the tax dispute concerning GLUC AI, the role of artificial intelligence in decision-making is analogous to the use of autopilot technology in the automotive industry, as illustrated in cases involving Tesla. The responsibility for any actions carried out using automated systems ultimately lies with individuals who configure and control these systems. So moving to the second argument, AI is not a legal entity. The claims that AI software hosted on servers in Salok Land shifts GLUC AI's tax residency ignores a fundamental principle. AI is not recognized as a legal entity under tax laws. According to international tax standards, only individuals and legal entities with legal capacity can be recognized as taxpayers. The decisions generated by AI are approved by Gluck AI's board in tax paradise land, making it clear that the company's effective management remains in tax paradise land. This is supported by case law such as HMRC versus Smallwood, which emphasize that the place of effective management is where real managerial decisions are made, not where supportive activities occur. So the third argument states that Sadakhland's authorities claim that Gluck AI is attempting tax avoidance, thus invoking the principal purpose test or PPT under the multilateral instrument. However, this claim is unfounded. Gluck AI pays taxes in tax paradise land at a rate of 24%, which is aligned with international norms. The use of AI to streamline operations is a legitimate business strategy, but not a scheme to evade taxes. According to Article 7 of the MLI, tax residency should be based on actual economic substance, not on technological tools used to optimize efficiency. Gluck AI's board of directors makes all significant decisions in tax paradise land, confirming that its effective management is located there. So I'm giving my next words to my colleague, Mr. Ayatullah.
Hello, members of the tribunal. Good day. I'm going to present 3 arguments. Firstly, I argue that Gluck AI tax residency should be recognized in tax paradise land. Under the paragraph 3, Article 4 of the Double Tax Treaty, which both states are party to that, the place of effective management determines tax residency if a legal entity is had the residency of both contracting states. Based on the facts in the page 6 of the current case, it has been indicated that the Board of Management and the Board of Directors held meetings in the territory of tax paradise, and their key decisions makings are made in the territory of tax paradise. Therefore, the place of effective management shall be considered that in the territory of tax paradise. Moreover, the board of directors are all humans and they are taxpayers in the tax paradise. Furthermore, the company Gluck AI is registered under the domestic law of tax paradise claimant's country. Therefore, the tax residency must be considered by this honorable court in the territory of Al-Gotland. Moreover, honorable arbitrators, Sadakhland position lacks basis under the DTT. Sadakhland may assert that Gluck AI place of effective management is in their territory. However, nor in the OECD Model Tax Convention or DTT agreement, and nowhere the direction or the management of the AI has been recognized as a place of effective management. Secondly, I argue that the application of DTT and MLI provisions prevents double taxation. The main goal for agreeing the SCTR agreement, DTT agreement, and MLI agreement between the both states are to prevent double taxations. It's the core objective for SCTR agreement that have been entered into force in the 1st January 2024 between both parties. Based on the fact of the case in page 6, it has been mentioned that the Gluck AI has been paid 24% corporate tax income to the tax authorities of tax paradise, and also Gluck AI, due to its economic operation in the respondent state, paid 12% value-added tax, and they fulfill their obligations under the multilateral agreement that they have between them. Therefore, the tribunal must recognize and grant tax credit for the taxes that have been paid in the territory of Al-Got tax paradise. At the end, I argue my third argument is that the Salok land had been violated its treaty obligation for not proceeding with MEP or mutual agreement procedure as outlined in the paragraph 6, Article 25 of DTT agreement. In TDT, the dispute settlement mechanism which is enshrined in the DTT agreement is not respected by the tax authorities of the respondent state. In the current case, based on the facts of the case, the claimant Glook AI has been requested for mutual agreement procedure, which was rejected by the tax authorities of Kazakhstan, which is an obvious violation of its treaty obligation under the Pactus Sunt Servendo principle, which is enshrined in the Article 26 of Vienna Convention on the Law of Treaties 1969. Moreover, under the Article 25 of DTT, it's also mentioned that there should be, regardless of the remedies provided by domestic law, if I could end of the quote, if both contracting states underscoring the MEP obligation, even regardless of the domestic actions that the remedies had been included in their domestic law. There's also proceedings for supporting my arguments. For example, the Winsley Days Settlement Trustee versus the Inland Revenue Commissioner that's adjudicated by the UK court in the year 1996. They also have been mentioned the board of directors meetings and the place of effective management is where their board of directors is located. So at the end, the agent for the claimant request for this honorable tribunal to adjudicate and declare, firstly, recognition of the amount 15 million as part of the cost of equipment. Secondly, Glook AI liability, the arguments of respondent for Glook AI liability for tax is invalid, and the respondent must refund the 20% of tax that have been withheld by them. And thanks a lot for your time and consideration, Honorable Court.
Thank you, Team 58, for sticking to the timeline. Dear judges, I think we might have questions, but if we ask them now, we might put the first team in a disadvantaged position. And I propose, oh, sorry, that's a timer. Okay, so I propose to now give a stage to the second team, listen to their delivery, and then go to questions.
David, my apologies. My apologies. Shouldn't we allow the other team to ask the questions?
Yes. Why not? We can do it now.
So because the idea was to give the option to ask 3 questions, and this should be finalized within 10 minutes.
Okay, we can leave it at the end, or we can do it now. If
do it now because everything might be just a bit.
Philip, case if you don't mind, we can give the second team ability to ask questions.
I'm very happy with that. My understanding was that after each presentation by a team, the other team would have the possibility of asking 3 questions of that team. And so Team 1 will have an opportunity to put questions. And then after Team 1 has made their presentation, Team 58 will equally have an opportunity to put questions so that they are both given equal opportunities.
Great, thank you, Philip.
Just from organizational perspective, judges can also ask questions if you would like to. So feel free, and this will be out of scope of timing limitation. So if you would like to ask 1, 2, 3 questions afterwards, that's perfectly fine. So
I'm happy to hold my questions until both teams have had an opportunity to present and to question the other. I'm happy to hold that until then. I don't know whether Case and Ravil, you're I think equally.
I'm leaving them to not put any of the teams into a disadvantaged position. So, team number one, please, your questions.
Thank you. So the first question would be, tax paradise land claims the premium under the Muraba contract isn't interest, but with a deferred payment structure and a 5% early repayment discount, isn't it clear this functions as interest under common international tax standards?
If I understood the question correctly, you were asking why is it stated as an interest when it is actually a riba. So my answer would be the fact that this is particularly important in the context of a transaction based on Islamic finance principles, where interest or riba is a term usually used in murabaha contracts and in Islamic financing that states the difference in payment when it pays in installments and when it pays immediately via one transaction. So thus the deferred payment premium should be treated as a part of the total cost of the equipment and not as the interest income. The attempt by Salafla and tax authorities to recharacterize this premium as an interest violates the substance of the transaction, contradicts the principles of substance over form, which requires economic reality to take precedence over legal form. So the substance of a foreign doctrine aims to prevent situations where the tax authorities, such as Salakla and tax authorities in our particular situation, are attempting to recharacterize the commercial deferral pay premium as interest income, which is an example of artificial taxation to make the taxable base more required. So according to Quran, the surahs 2.275 and 2.272, riba or interest is strictly prohibited. So that's why it is important to note that our claimant used the different type of our claimant offered to the defendant side the different types of payments, and it was noted that 100 million euros is a price that should be paid immediately, should be considered if it was paid immediately. So that's all.
Sorry, can I quickly add something to answer of my team? It will be
Sure.
In his work, Legal Regulation of Islamic Finances in Republic of Kazakhstan, Professor Osipov mentioned that mudaraba in its essence is financing or trade operation. So like according to the formula of murabaha, it means cost plus markup. So the root rabaha means to extract profit or to win. That's all.
Thank you. Defendant teams, any other questions?
Yeah. So how does Legoland's rigid stance align with the Vienna Convention's emphasis on the interpretation of treaties in good faith and in light of their purpose, which seeks to prevent both double taxation and tax evasion? Would a flexible interpretation not be a better serve the would not better serve the treaty's aim? Is it clear?
Yes. Thank you so much. Can we have 1 minute to discuss the answer?
1 minute would be too much time. Use your 15 seconds, please, and go.
Okay.
For answering the Honorable Respondent Counsel, the text of Vienna Convention on the Law of Treaties, especially the Pactus sunt servanda and Article 22, 26, and especially 31, the interpretation based on the good faith 32, it's a part of customary international law, and it's a norm that is used for interpretation of treaties based on their objective. The objective of the STTR and DTT is to avoid double taxation between both countries, which is not regarded and considered by this by the state of respondent. And also Article 25 of DTT is similar to the OECD Tax Model Law Convention. It's clearly indicated that suggested the dispute settlement mechanism as a MEP or a mutual mutual agreement procedure, which is a custom for solving tax dispute between the estates. It's a normal practice that's used in the UAE and around the world. And in this case, the refusal of respondent state, we believe, is the violation of its treaty obligation and not acting according to its international obligation under international law. Thanks a lot.
Thank you, KazNU team. So, team one, you still have a chance to ask one more question if you want.
Given that the tax paradise land asserts that the STTR was incorrectly applied, so does this not give a scope for preferential treatment of the premium in tax paradise land's favor? How do we address Salik land's legitimate concerns about ensuring that the cross-border income is taxed appropriately?
Well, I don't know, team 58, whether the question is clear, but it seems that it's the question refers to the first two questions, so it's kind of repeating in some sort. But if you're happy to answer, please do.
If I understood the question correctly, you are asking why we are applying the STTR if it was noted that MAP was not agreed upon from the Southland's perspective. So the tax authorities of Southland believes that the tax authorities of Southland believe that tax authorities have misapplied the provisions of STTR to FPBT's income related to the different payment premium. STTR is applicable only when the income is not taxable or is taxed at a reduced rate in the country of residence. However, this rule cannot be used in this case as the income from the bonus has been properly included in the taxable base in tax paradise land and taxed at the standard effective rate of 24%. The tax authorities in tax paradise land already confirmed that the FPPT has fully paid income taxes, including the deferral premium at a rate of 24%, which is close to the rate applicable in Southland, which is 25%. Consequently, the assertion of the Southland tax authorities that income in question could be exempted from taxation in Southland and was subject to withholding tax in Southland was not in accordance with the factual circumstances. The income has already been taxed in the country of residence, and a situation of double non-taxation does not arise from this situation. So the allegation that the company is trying to avoid taxation is not sustained, as the difference in rates between FPBT and Southland is insignificant, and the tax has been paid in full. So the tax difference between both countries is 1%. So my colleague wants to add something.
I would like to add that there's just 1% difference of tax rate between these countries. In the case, even if the court consider the payment, there should be payment of 1% tax difference. That's 25 in the respondent state and 25 in the claimant state. Thanks a lot.
So,
thank you. We're done with the questions. So Philip, Case, are we ready to give a stage to team one for their delivery? Yes, okay. Go ahead, team one.
So the council one, I'm council one representing the respondents in this case. Before I begin, I would like to seek your permission to proceed with the issues. My issue one would be, does SPS constitute a permanent establishment of FBPT under Article 5 of the DTT? Firstly, under Article 5.1 of the OECD Model Tax Convention, a PE is defined as a fixed place of business through which the business of an enterprise is wholly or partly carried on. In our case, SBS served as this fixed place of business for FBPT in Salikland. FBPT owns 100% shares of the SBS and directly controls its activities within Salikland. This ownership and control demonstrates a stable and ongoing commercial presence, fulfilling the fixed and enduring criteria for a PE. Now, under international customs, a PE requires a substantial and enduring commercial connection. Similarly, SBS is an exclusively used by FBPT to execute essential contractual obligations, indicating FBPT's significant economic footprint in Salik land. FPVS contributes directly to FBPT's operation, effectively acting as a fixed place of business for FBPT. Now, I would like to use the case of Rolls-Royce versus DITC as a persuasive precedent. This case introduced that at the disposal test, if a foreign entity repeatedly and purposefully uses a subsidiary's facilities and resources, it can establish PE status, SBS, at the disposal of FBPT. FBPT utilizes SBS's resources and offices to conduct its business in Salikland. FBPT's control over SBS's financial transactions and managerial decisions further cements this relationship. Secondly, let us consider the place of effective management, that is POEM, under Article 4 of the treaty. The POEM determines entity's primary residence when it could be considered resident at both the places. Now, according to the OECD commentary, the POEM is typically where the key management and commercial decisions are made. In this scenario, while FBPT provides oversight, the actual management and operation of SBS are indeed conducted in Salik land. So this indicates that SBS's effective management is actually in Salik land, aligning with the operational activities. Now, thirdly, under Article 5, subclause 5 of the OECD model, a PE exists when an agent acts on behalf of an enterprise and has the authority to conclude contracts in the name of the enterprise. SBS acts on behalf of FBPT and has the authority to conclude contracts. In the case of Nortel Networks India International Inc. and the case supports where an agent with the authority to conclude contracts was held to create a PE. SBS's role in concluding contracts and conducting business for FBPT established it as a dependent agent in the PE. Lastly, the principle of economic substance over legal form. This emphasizes that the real nature of relationship takes precedence over its formal structure, even though the SBS is incorporated under Salikland law. Its operational and financial dependence on FBPT shows its function as FBPT's arm in Salikland. Now, moving on to the issue 2, does the $15 million markup constitute interest and is subject to the withholding tax? It is a well-established principle in international tax law that the economic substance of a transaction takes precedence over its legal form. Article 11 of both the DDT and the OECD Model Convention defines interest as income from debt claims and every kind, including compensation for the use of forbearance of money. In the case before us, although the Muraba transaction is legally structured as a sale of commodities, the economic reality indicates a financing arrangement. The 15 million markup represents compensation for deferring payments over 5 years, effectively serving as interest for the use of funds. At Muraba transaction, traditionally used in Islamic finance, involves selling goods at markup with deferred payments. This arrangement mirrors a loan where the markup compensates for the time value of money. Thus, the 15 million difference between immediate purchase price and deferred price functions as a financing cost, characteristic of interest income rather than a simple profit from sale of goods. Now, I would like to add the case of Chevron Australia Holdings versus Commissioner of Taxation. That would also serve as a persuasive precedent that a related party loan with high interest rate as a financing arrangement subject to interest withholding tax emphasize the transaction's economic substance over its form. Also, in the Supreme Court of India held that tax authority should look beyond the legal form to substance of transaction when assessing tax liability. Applying this principle, the substance of the transactions between FBPT and SBS indicates a financing arrangement with interest income. Salikland imposes 9% withholding tax on interest to non-residents. Since the 15 million markup functions as interest, it falls with the provision. Furthermore, FBPT has a permanent establishment in Salikland through SBS. Under Article 11, subclause 6 of the DTT, interest attributable to a PE is taxable in source country, justifying the withholding tax. In light of economic substance over legal form principle and supporting the case, the 15 million markup should be reclassified as interest. Therefore, Salikland imposition of 9% withholding tax is justified under both domestic and the DTT provisions. Moving on to the next issue, application of the subject to tax rule STTR and treaty benefits. Finally, we address whether Salik lands tax authorities have violated the DTT by applying withholding tax under the STTR. The STTR is basically designed to prevent treaty abuse and ensure that income is taxed in at least one jurisdiction. It allows the source country to apply a withholding tax when the recipient's jurisdiction does not subject the income to sufficient tax withholding. Now, for the purpose to prevent treaty abuse under the multilateral investment provisions, if one of the principal proposes an arrangement is to obtain treaty benefits improperly, these benefits can be denied. In this case, FBPT is situated in tax paradise land, a jurisdiction known for low or zero taxation. The arrangement appears designed primarily to minimize tax liability, suggesting treaty abuse. Now, I would also like to cite Mayor and Co versus France. The Court of International Tax Court upheld France's denial of treaty benefits where the principal purpose was to obtain a tax advantage, supporting the application of anti-abuse rules. Also, in the case of Lukoil Pan Americas versus the Netherlands, the Dutch court denied treaty benefits, emphasizing the primary motive of transactions should not be tax avoidance. And if you also look at Article 23 of the DTT, it obliges both the countries to provide relief from double taxation. However, tax paradise land's refusal to grant a tax credit for the withholding tax undermines this obligation and contributes to double non-taxation, which the DTT aims to prevent. Salik land's actions are consistent with the international efforts to ensure that the profits are taxed, where economic activities generating them occur. By applying them withholding tax under the STTR, Salik land is upholding the integrity of the tax system and preventing erosion of its tax base. Furthermore, to conclude this, Salik land application of the 9% withholding tax under STTR is indeed justified and does not violate the DTT. It is necessary to measure. It is a necessary measure to prevent treaty abuse, ensure appropriate taxation, and comply with the international tax principles. I would like to pass on to my co-counsel.
Members of the tribunal, good day to you all. Your Lordship, this is Counsel 2 representing the respondent. I will be addressing the Honorable Bench on the 3 issues under Episode 2 concerning the challenge. Your Lordship, the first issue in this case pertains to the determination of place of effective management based on substantive management control in Salik land is correct. Firstly, the GLUC AI's place of effective management should be recognized as in Salik land due to substantive AI-driven control within the jurisdiction, emphasizing the importance of substantive business operations in establishing place of effective management over nominal board operations. By this analogy, Salik land's AI system, Salik AI, controls all substantive decision-making processes, making Salik land the de facto place of effective management. Secondly, AI's role within the GLUC AI extends beyond mere advisory capacity, imposing binding operational decisions which the board is contractually obligated to follow. This establishes place of effective management control in Salik land. Secondly, GLUC AI's residency should reflect the factual control and operational management located within Salik land, prioritizing actual management practices over nominal board locations. Since GLUC AI relies on AI-based management within Salik land, this aligns with the criteria for recognizing the place of effective management based on factual management location. If the bench is satisfied with the issue number 1, the council seeks permission to proceed with issue number 2.
Yes, please.
Proceeding with issue number 2, whether that the DTT permit denying a tax credit for tax paid in tax paradise land due to the place of effective management as outlined in Article 4, paragraph 3 is valid. Firstly, the determination of tax residence under Article 4, paragraph 3 of the DTT, which clarifies that an entity that qualifies as a resident of the both contracting states shall be deemed as a resident of the state where the place of effective management is situated, which in our case is the Salik land. Secondly, based on the factual circumstances presented, GLUC AI's business operations are centrally managed by an AI-based system located in Salik land, directing decisions
without substantial oversight over its directors in Lagotland. This reliance on AI for key managerial decisions implies that the true locus of control and effective management lies within the Salikland. Secondly, the OECD commentary on Article 4, paragraph 3 underscores that place of effective management is a decisive factor in cases of dual residency and aims to mitigate double taxation through a consistent application of residence principles. As both countries adopted the MLI provisions effective from January 2022, the principle of effective management is further reinforced, further supporting Salikland's claim to tax Gluk AI's income without crediting foreign taxes. Fourthly, the OECD commentary on Article 25 suggests that the mutual agreement procedure is not obligated if both countries are firmly adhering to the double taxation treaty terms, since place of effective management clearly positions Gluk AI's residence in Salikland. Any appeal for further MAP engagement lacks permit. And Salikland's tax authorities have a strong basis for denying a credit for taxes paid in Lagotland. Proceeding with the issue number 3, that is, the Salikland tax authorities' refusal to engage in MAP, citing the suspension and non-applicability of double taxation treaty due to differing tax residency determinations is justified and under international tax laws. Differing determinations of residency constitutes a valid reason to suspend the double taxation treaty's applicability, therefore justifying the decision under both domestic and international law frameworks. Firstly, interpretation of residency under the OECD Mutual Tax Convention and domestic laws. Article 4 of the OECD model. Salikland's domestic tax code asserts residency based on the place of effective management, defined as the center of the overall business management, which it has established as being in Salikland based on the AI-directed control over Gluk AI's strategic decisions. Secondly, Salikland's right to uphold the DTT benefit based on the OECD Mutual Taxation Convention, Article 4, until residency is clarified, is also supported under the Treaty Suspension Board on Residency Dispute under Tech Innovation Limited Switzerland versus Italy. Thirdly, without a justified residency determination, there is no clear basis for the double taxation treaty applicability. Therefore, Salikland's refusal to engage in mutual agreement procedure pending a resolution of residency determination is justified under the OECD MTC principles. Furthermore, the 5% withholding tax outlined in Article 11 is not applicable in the DTT suspension. Subsequently, the Salikland stance on applying the domestic tax rates in the absence of DTT provisions is justiciable under the OECD and domestic regulations. Fourthly, the Salikland's interpretation is further supported by the multilateral instrument adopted in 2022 among the parties, which amends the DTT and includes provisions for the subject to tax rule STTR. Furthermore, the Salikland stance on MAP refusal and treaty suspension aligns with the established OECD principles and international tax laws, providing a solid precedence without DTT benefits until residency is mutually agreed upon. Until the residency of Gluk AI is mutually determined, Salikland has grounds to withhold the DTT benefits, suspend the MAP participation, and apply the domestic tax laws consistent with the OECD guidelines on the treaty interpretation. The Council seeks permission to proceed with the request for relief.
Please.
On behalf of the respondent, the Republic of Salikland, the respondent respectfully requests the International Tax Court to, first, declare that the premium in the contract between the FBPL and SPS constitutes interest and should be subject to 9% withholding tax in accordance with the domestic laws of Salakland and the DTT as modified by the multilateral instrument. Secondly, declare the imposition of the 9% withholding tax on SPS in the absence of a permanent establishment of FBPL is consistent with the provisions of Article 11 of the DTT. Thirdly, declare the Gluk AI should be considered a tax resident of Salakland based on the place of effective management and Article 4 of the DTT. Fourthly, declare the refusal of the offset paid by the Gluk AI is justified under the domestic tax laws of Salakland and MLI. Fourthly, direct the applicant of the Republic of Lagotland to honor its obligations under the DTT and recognize the tax liabilities arising from the SPS operations in Salakland or grant any other relief which the Honorable Court deems appropriate and fit. Thank you.
Thank you, Team 1. Also, thank you for sticking to timeline. Team 58, your questions. Penny,
Would you
please.
mind, presiding
Philip.
judge, before Team 58 pose their questions, might I clarify one point with Team 1, because that may be relevant to the questions that are going to be posed to them. As I understand it, Team 1 are contending that FPBT, the First Partnership Bank, has a permanent establishment in Salakland by virtue of the subsidiary SPS, and presumably, therefore, the full profit on the sale of the oil refinery plant is taxable to that permanent establishment. But I'm not quite clear whether they are contesting that the 15 million is interest or not. I read their written memorial for the respondent, and it wasn't clear to me whether they were accepting that the 15 million was not interest. At pages 4 and 5, they refer to, for example, page 15, I'm sorry, not 4 and 5, 14 and 15. At page 15, they say, in conclusion, FPBT respectfully submits that the 15 million markup does not constitute interest. Of course, they are not acting for FPBT, but they are acting for Salakland, and that left me with some confusion as to whether they are or are not arguing that this 15 million constitutes interest, or whether they are conceding that it does not constitute interest. And I'd like to clarify that point because it may well be relevant to the questions that Team 58 are going to put to them. So perhaps Council 1 for Salakland could clarify their position on whether it constitutes interest or not.
Mr. Arbitrator, it does constitute as an interest. This is a typo on our behalf. My apologies.
I'm sorry, I didn't quite catch that. Could you possibly repeat that?
This does mean that it did constitute as an interest. This was a typing error from our part.
We humbly apologize for the mistake.
There's a typo, Philip. Is it clear?
There's a typo in the memorial then, is that? I see. Okay. Thank you. Thank you for clarifying.
Thank you, Philip. So, Team 58. Sorry, Case, maybe you have questions or clarifications? No. All right. Team 58, go ahead.
So, why tax authorities of Salakland demand the payment of 9% if Article 11 provides a 5% withholding tax rate on interest?
Team 1, is the question clear for you?
Yeah, we would like 1 minute of
think about the.
Sure.
We would like 1 minute to think about the question.
Okay.
The council would like to plead ignorance for this.
Accepted. Team 58, another question.
Yes, we have the second question. So according to your third issue, do you agree doing mutual agreement procedure that was requested by GLUKI with Salakhlet authorities? Is it clear, my question, Team 1?
Yeah, once more. Could you rephrase it?
Okay, so you wrote in your third issue that you are saying that MAP had to be established. So my question is, do you agree doing mutual agreement procedure that was requested by GLUKI with Salakhlet authorities?
Team 1, are you ready to do MAP or not?
Yes. The Tajikistan tax authorities' refusal to engage in the map process is certainly on the procedural aspect that the GLUK AI's residency has not been determined by both the countries, and it has been contested on part of both the countries. Since until the determination of the residency is not clear by the GLUK AIs, thus the Tajikistan tax authorities' refusal to engage in the map process is justified.
Thank you for your question. Thank you for your answer. So,
can we ask our third question?
Well, actually, it will be your fourth question, right? Fourth question. But you still have time. What do you think, judges? I don't know. I don't mind because they have time. Yeah. Okay. Okay. Please.
Sorry for interruption. It will be our third question, not fourth.
Okay. Go ahead.
Yeah. So our question: do you recognize or admit software as a subject of law?
I would like a minute of research work.
Team 58, is it correct that you're referring to AI software, not any software?
Yes, it's AI software.
Okay, okay.
Answering to my learned counsel's point that we do recognize the legal backing of the AI software, as since in our present case the major operations of the GLUK AI are being done and operated by the AI Salik AI system, and moreover, a major of the operations which are being directed to the directors are binding to be contractually done by the directors on the request and the recommendation of the AI procedures. Thus, we do recommend. Thus, we do agree to the point that AI is being under the legal recognition.
Thank you for your answer.
Thank you, teams. Case, please.
Yes. I would like to refer to a point, and to be honest, from my notes, it's not perfectly clear whether there was a point made by Team 1 or by Team 58, but while explaining the nature of the interest, I heard that occasionally reference was made to domestic law. And my question is was it indeed done? And if so, what's the basis for referring to domestic law when you're discussing whether a particular payment is or is not covered by Article 11?
Let me clarify straight away. It was Team 58 who referred several times to domestic law, so please answer that.
Was my question clear, Team 58?
Yes, it is. It is clear. Are we allowed to take 1 minute to prepare our answer? So thank you. We are firstly referring to the international agreements and to international law as our first basis and our main basis, and we're referring to our domestic law as a secondary basis, and we are referring to it as an analogy. We are using it as an analogy to stand and the state practice and to support our arguments and to support our points. Was my answer clear to you?
Your answer was perfectly clear to me. Thank you.
Let me ask a clarification question with respect to the same issue. Team 58, you referred several times to local law, but you chose to refer to different jurisdictions. I mean, you refer to civil law of Kazakhstan, to tax law of Russian Federation. Why is that? What was the rationale for that?
Mike, I would like to proceed that it's not only the case of Kazakhstan and Russia. Majority of states have the similar state practice, including the UAE. And the recent regulation change in the year 2024, they imposed 9% in tax, corporate tax income, and this raised the question of POEM, or place of effective business management, and they have the certain regulations regarding the criteria for the establishment of place of effective management, where the first criteria is the effective decision-making position, and also the board of directors' place and their registration. If in the case they fulfill this criteria in the territory of United Arab Emirates, they are subject to taxations. That's why maybe my colleague add more clarification.
Yeah, sorry. Thank you so much. Yeah, we're using domestic law of Republic of Kazakhstan, and we're also using law of the Russian Federation as an example to show the practice of this kind of countries. And as my colleague, Mr. Ayat said, their laws like tax code or civil code, they are really close to each other. They kind of like common maybe, so that's why we're using this types of law. Thank you.
Case, another question for you.
Yes, also for Team 58, my question is whether the explanation I heard about the AI company not being capable of being a taxpayer because it was, it's AI, but AI is sort of a facility exercised by a legal entity. So did I understand you correctly that you were disputing the status of that company? Because it's stated here, Adam AI is a legal entity. Are you disputing the status of the legal entity as a possible resident on the basis of its way of operation? Or was there a different argument that I apparently missed understanding? Is my question clear?
Yeah. Could you rephrase your question maybe? Because can you make it more clear or shorter? Yeah, or shorter.
Yes, let me try. So my understanding was, but maybe I misunderstood. My understanding was that you disputed the status of Adam AI as a resident taxpayer because of the nature of AI, and you did not address that Adam AI is a legal entity that effectively engages in AI, but it's an activity. That's not the person itself, I would think. But was my understanding that you argued denying the resident status of the legal entity on the basis of its AI activity?
Yes, Honorable Arbitrator, because if I quote, sort of the quote based on the page 6, it said, it reads as a follow: Gluck AI is a legal entity registered under the laws of the tax paradise land and as recognized as a tax residence of tax paradise land. End of the quote. And another area, it has been mentioned in the fact, sort of the quote, there's a board of directors consisting of humans. End of the quote. Due to factual circumstances, in our case, there are real humans. They are meeting every year and deciding on important matters and leading the company. That's why we are arguing that the presidency must be considered based on the registration and place of directors, not AI.
And let me add more words. Despite its technological advancement of AI, it is merely a tool to assist the business operations of the Gluck AI.
But forgive me, may I come in on that point? Because you've quoted from that factual statement, there is a board of directors consisting of humans. But if you then read on, it says, but their contract with Gluck AI, approved by the shareholder, obliges them to follow the decisions of the AI based on the software. The board of directors, consisting of individuals who are tax residents of Tax Paradise Land, meets quarterly, but they sign the minutes prepared by the AI based on the software without any discussions. These are human beings, but they are acting as automatons. They are acting under the direction of the AI software. How can you say that they are the place of effective management if they are their whole human decision-making function is given over to the operation of AI?
Because look, Mr. Philip Baker, we do not recognize AI as a subject of law. That means that AI is not have a legal capacity to bear any legal consequences that will occur like in the future. So the humans, they're recognized and they are the residents of the so according to the international laws, yes, the humans are capable and can bear tax obligations. So even the AI is operates the business, the financial situation, the pricing, the last movement and the last words are made by the humans.
Can I also add, please, some words?
Sure.
While presenting the position for the second episode, my colleague, Mr. Islam, he mentioned the case with Tesla. So even the decision made by AI software, the consequences appears like for the people. So, and in the end, people are the one, like human is the one who will solve the some kind of problems that AI can make.
Philip, can I ask? Well, we need to have some balance here. Team 58 is answering
Yes, would you mind if
questions.
I tossed a question to Team 1, because Team 58 are getting all the questions. If I may, as I understand it, Team 1, your first argument is that FPBT has a permanent establishment by virtue of its control of a subsidiary. Article 5.7 of the treaty reads, the fact that a company which is a resident of a contracting state controls or is controlled by a company which is a resident of the other contracting state, or which carries on business in that other state, whether through a PE or otherwise, shall not of itself constitute either company a permanent establishment of the other. Surely, in the absence of evidence that SBS either made its premises available to staff of FPBT, or that SPS concluded contracts regularly binding on FPBT, Article 5.7 must have the effect that there is no permanent establishment. What do you, Team 1, may I ask what you say to that point? You can have a minute to think.
So, just for clarification, could you just shorten the question?
Yeah. Your primary argument is FPBT has a permanent establishment through its subsidiary, but Article 5.7 says having a subsidiary in a country does not of itself give rise to a permanent establishment. How do you get around that particular point?
To say this under DTT's Article 4.3, here it can come under dual residency. Here,
Forgive me, I'm not asking about episode 2. I'm asking about episode 1 or scenario 1. It's not a question of dual residence. It's the question of whether or not there's a permanent establishment as a result of having a subsidiary. And I understood that was your primary argument, both in your oral submissions and in your written memorandum as well.
If I may add to that, I specifically would like to know the extent of the disposal of a disposal of the one company in the company of the other company, the subsidiary. I just want to expand on the comments of my learned brother, I guess.
Sir, I would like to go on with that. SBS, as you told, is 100% owned by FPPT, but they did come into a commercial transaction, and they do have they did try to disassociate themselves by having an independent commercial transaction in the Salikland state. And I've also used the persuasive precedence, where a P requires a substantial and enduring commercial connection. So here in this case, SBS did have a commercial connection in Salikland, and it did leave an economic footprint in Salikland.
Also, sir, adding to my counsel's point, there was a fixed place of business which was run in the Salik land by SBS, which was 100% owned by the FPPT. Moreover, all the functions were also carried in the Salik land itself, thus highlighting to the point that the Salik land is that the SBS has the residency of the Salik land. Thus, they should not be subjected to lesser tax residence.
Philip, any other questions?
Well, I did have a question for Team 58, but
It's okay.
we put there.
Sure.
Let me ask this actually. FPBT is a bank, and yet it sold equipment to SBS. And I'm certain you're going to tell me that it sold equipment as opposed to providing financing, because this was a Murabaha contract, and the compensation for providing the price for the equipment is a markup in the cost, not interest, in order to avoid the prohibition on riba. So I'd like you to comment on why a bank is selling equipment if it is not earning money by providing financing for the acquisition and sale of that equipment. And my second question is just for clarification. I see that FBPT is a resident of a tax-exempt special financial center. Is it your understanding that therefore FPBT paid no tax on any profit arising from any of this transaction?
Thank you for your question. Can we have 1 minute to discuss the answer?
Sure.
With pleasure.
Thank you. So before I told about the Professor Osipov, so in his work Legal Regulation of Islamic Finance in Republic of Kazakhstan, he wrote that Mudaraba in its essence is financial trend operation. So the bank finances is a commercial transaction receiving a pre-agreed profit from. For example, the bank purchase a product in its own name and its own expense based on a client's order, for example. So each commercial contract based on Murabaha, it must be structured around a real asset, which is understood as product, maybe goods, services, and even intellectual property. So however, if bank were purchase and store goods like in anticipation of selling them, it will shift from being a financial intermediary to trading organization. So I think in this situation, it's clear why FPBT, SBS, they are selling this kind of product because bank doesn't need any instruments, maybe any goods for this kind of industry. So that's why they're selling the product. My colleague will add some more.
No, I don't know.
So I want to answer to your second question. IFC, or International Financial Center, has specific regulatory rules aimed at creating transparent conditions for conducting international businesses, including the prevention of tax regime abuses. So companies registered in the IFC must comply with strict requirements for transparency, corporate governance, and reporting. This means that FPBT operates in accordance with international standards and cannot use SBS to avoid taxes. The status of an IFC resident confirms that FPBT conducts its activities in good faith and transparently, reducing the likelihood of SBS being recognized as a permanent establishment. So SBS is an independent legal entity and operates autonomously under the local laws of Salakhland. The defendant claims that the SBS acts as a dependent agent of FPBT, thus creating a permanent establishment. However, as an international financial center resident, FPBT is subject to strict financial control and regulation, eliminating the possibility of creating structures for tax optimization. The IFC status also confirms that FPBT is engaged in real commercial operations, not using SBS as a formal, nor the defendant's arguments about the structuring being that's
But forgive me, Councillor Toknai, may I just press you on this point? Did FPBT, was it liable to tax in tax paradise land on any of the profits from its activities?
Sorry, do you mind to please?
Yeah, was FPBT liable to tax on its profits in tax paradise land? It operates in the IFC, and we're told that the IFC is a tax-free zone.
Yes, I think yes.
Yes, because even if FPBT is resident in International Financial Center, it doesn't exempt from all types of taxes.
Thank you. Okay.
I would like to ask one hypothetical question to Team One. Let me break the rules for a minute. The facts are silent on this, but let's imagine that Gluk AI has internal policies which provide that if the software makes a criminal or potentially clearly damaging to the company decision, the board of directors would have a right to refuse to sign that resolution. If that would be true, would it change your analysis? Would it change your position in this case?
With respect to your lordship's question, I would just like to highlight that in that scenario, there might be there might be some situation that that the board of directors might disagree with the AI-based recommendations in term when it's matters of criminal procedures or criminal matters. But in our present case, it is uh, solely that the AI are making recommendations, and the board of directors have to the board of directors are contractually obligated to follow all the recommendations which the AI operations had designed it. Thus, in present case, we feel that the that the con- that the effective place of management in Salak land is correct, but in case of the present situation presented by your lordship, it might happen that the board of directors might refuse, and that might change the situation altogether.
Okay, thank you. Case, Philip, any other questions before we end this round and go for judgment?
I have no further questions.
All right, Case, out from you.
No further questions. Thank you.
All right, thanks. Well, now we can together with all the. Oh, okay, Rustam, thank you. We have to join another call and using the link provided by Rustam just now. So I'm asking teams to.
Do the teams not get an opportunity to finally respond or close?
Of rebuttals, right? Thank you,
Rebuttals,
Philip.
sorry.
You have the right for rebuttal. You have up to 3 minutes to summarize your position, but not more. 3 minutes strictly. If you'd like to do that, then the first one would be Team 58.
Thanks a lot for giving floor for claimant. The claimant would like to raise one point regarding the AI. We argue that AI is not subject to law based on the international law practice in different sector of the law. For example, in the case of autonomous weapon and AI involvement in autonomous legal weapon, the international law have been recognized the command principle. The person or the authority that authorized to act of AI recognize the person and the authority subject to law, not AI. And also in the case of tax law, there's also no treaty rule or also a state practice to holding AI and subject to law or taxation. Therefore, we argue that the AI is not subject to law, and that place of effective management of global AI is in the territory of tax paradise. Thanks a lot.
Can I also add some more? Also, as we said before, FPBT is a resident of International Financial Center of Tax Paradise Land, operates under strict compliance standards, including rigorous financial disclosure and adherence to international tax standards such as the OECD and MLI guidelines. Its transaction with SBS involving a 5-year installment payment for equipment reflects genuine economic activities, not mere formalities or tax-driven objectives. Thank you.
Oh, thank you for such a focused rebuttal. Clear. Team 1 in the international.
Yeah. So I would like to begin the sir rebuttal with not answering, just saying for my views that the final statement by my learned counsel of the petitioners was that FPPT, it does class regulation, but the fact sheet is silent about that, obviously. And also, I would like to go on with saying that as the other council had said that they used Kazakhstan and Russian code of civil as a as they found it similar to the current scenario. But I would like to say again, the fact sheet is silent on that matter, and they would merely hold a persuasive manner in the International Court of Tax. So, yeah, I would like to conclude. Thank you.
Second counsel, anything from you?
I would just like to substantiate my the earlier points highlighted with us, that that most of the substantive decisions were taken by the AI-driven control, and the board were just looking over for the nominal board locations in the Lagot land, and moreover the board was contractually obligated to follow all the decisions made by the AI-driven without any further discussion, and it was just a formality from their side that that meeting of the location was on Lagot land. Moreover, substantiating to the point that the map procedure which was refused by the Salik land tax authorities by the respondent was due to the fact that the residency of the GLU KI was not totally declared or agreed upon by both the contracting parties. Thus, the tax authorities have a right under the OECD model and the multilateral instrument to refuse the MAP process.
Thank you. Thank you, Team One. Okay, so we are now moving to another Zoom call. Philip, case, we have to use the link provided by Rustam. Team 58, Team One, I'm asking you to wait on this call. We will return with the judgment soon.
Meanwhile, the teams, some feedback from my end as one of the organizers. You did, sorry, just I will. Well, I was contacted by organizer because they lost case Van Rat, so well, now he joined. A few comments from my end. I really admired the game. I really admired your creativity, and from what I know about these professors, they had a lot of sympathy and respect to your game. So I used to be the student just as you. I used to be a student at a certain point in time, like 25 years ago, of Case Van Rat program. And it is said on the one hand, there was a brilliant game, so we really couldn't cut it off. But here, in the waiting room, there was a head of tax of Bolt. Bolt is a big taxi aggregator. This is like European version of Uber. He was waiting for 1 hour to deliver his comment on the game, but then actually just a few minutes ago, he had to leave for another meeting. But I'm sure we will record his feedback. He was very interested as well in your presentations. And what we wanted to share with you is that this is not just about the game. This is not just about well, presenting cases. This is really a great opportunity for young individuals, for learning tax consultants, lawyers, to develop their skills, to develop their personal brand. I also invited a few other friends of mine working in the area of taxation to give their comments while the judges deliberate their conclusion. And I just want to encourage you, by all means, to pursue your interest in international tax, to continue with studies of this subject. Lots of interesting stuff. It might seem that some of the points which we were discussing today are well, kind of not that much relevant at this point in time, but specifically with Bolt, for example, this taxi aggregator, they will be dealing with artificial intelligence management pretty soon, or maybe they're already working on this, because he was in particular very, very much interested in joining and commenting. We just missed the opportunity to get his presentation alive. In respect of further steps in this moot court, we are going to have the Russian language version finals in 2 days from now. It will be taking place live. It will be taking place in Almaty on Saturday. And those who are listening to this presentation, I cordially welcome you to this particular presentation, the offline rounds of the Russian Language League. And on 15th of November, we will have the battles of Professional League, because not only students participating, we made slightly more sophisticated assignment, a slightly more sophisticated the case description for young lawyers who already work as a first year law assistants and tax consultants. So there are going to be a lot of interesting battles, interesting discussions. And I'm pretty much sure that all of you already already improved your international tax knowledge quite a lot. And I would encourage you to stick to this path and develop your knowledge and expertise in this area. You can also give some comments meanwhile. You can also give some comments meanwhile, like your address to other participants, other students. We will pass it on to your colleagues and let's say maybe future friends from the Russian-speaking league. And I would just start from the Indian team. What would be your message to teams which will be playing this game in 2-3 days from now?
We wish them a very good luck for their rounds, and also we also will be very willing to engage in all such further events.
We did enjoy this moot court competition finals. It was a bit overwhelming, I would say, but as we say, it was a great experience.
Okay. Good. Good.
So we would also like to thank the tribunal and the organization for the honor to be present in this tribunal. So we are very thankful to participate in this moot court. It was a very good experience for us. So,
and thank you, organizers that made the whole work to organize a moot court and to provide us a very beneficial experience. Thank you.
Okay. Well, I will pass on your regards to Ravil Kasilgov, who did quite a lot of work, and he helped a lot with organizing this, with facilities, with the staff support, and he is very much willing to support the younger lawyers, younger tax experts to develop their skills, to grow personal-wise. If you will be in position to join our 15th November meeting, there will be very interesting game of one of the teams which won already several international competitions, and they were just students as you, just a couple of years ago, and they did huge progress. Over the last couple of years. Indian team is also most welcome to come to Almaty on 15th and 16th of November, but considering distances and difficulty in travel arrangements, you would be excused if you do not attend. So not an issue at all with this. But it would be good if you continue participating in this. In these activities, because it's also very, very important to keep cross-border communication, cross-border exchange of thoughts and views, because even during this team, it was very clear that you are coming from very different legal backgrounds. And you learned a lot from each other. I'm pretty much sure you learned a lot from each other. There were great things which Indian team was doing. There were very interesting thoughts and creative ideas by Kazakhstani team. And the purpose of all these events and activities is to allow young people to meet, to discuss, to learn from each other and basically develop. That's it. Okay, so we can have a little break waiting for the final judgment. If you would like to comment on anything, feel free to do so. Otherwise, we can just wait for some time. And by the way, in India, do you say chai or do you say tea? Because
we go on with chai. Chai is the same as tea.
Okay, good. Because in Kazakhstani language and Russian language is also chai, and people believe that it was coming from India, maybe from neighboring regions. And there is an interesting story that the regions which imported it by land line, which imported basically by land, they use the word chai. Because in the place where it was originated, maybe India, they used the word chai. And the nations which imported it by sea, for example, England, the Netherlands, other countries, they use the word tea or derivatives, because in place from where it was exported by sea, they use this word tea, not chai. And pi, what does it mean in Hindi? I think it's Hindi language. So this wording, Rusi Hindi or Kazakh Hindi, pi, does it make any sense?
I would beg pardon. Could you repeat?
Rusi Hindi, pi. Does it sound any familiar?
Yes, we have heard about this.
Okay. And what is the meaning of this?
That the Russians and the Indians are brothers.
Okay. So, and if you say Kazakhstani, so how would it sound in Hindi? Kazakh, Kazakh Hindi, bhai.
Kazakh Hindi, bhai. Yeah.
Okay, good. So, we learn at least something from Hindi.
Yeah. So how would it go in Russian language?
Индийцы и казахстанцы или казахи, братья. So I just use straightforward taxation. And well, in Kazakhstan, there are Russian is widespread, but this is not really authentic language. Authentic Kazakh language is more like a Turkic style. So this and well, I don't speak Kazakh, unfortunately. So Team 58 help us to say Kazakh Indie brothers in Kazakh language.
Yes, in Kazakh language, it will be Қазақстандықтар және де үндіс халқы ағалы болып келеді.
Okay, well, that's more difficult. That's more difficult. That Kazakh Hindi high, but we need to learn. I know in Kazakh language, mırzalar hem
Ханымдар, мен мырзалар, like ladies and gentlemen.
Yeah, ladies and gentlemen, Mirzalar and Hanımlar, yeah, Mirzalar, Hanımlar, but well, also just picked up very few words in Kazakh, unfortunately, and there is also Kazakh Jaksi, yeah, Jaksi. Does it?
That's it's mean like good.
Okay, it's okay. Like, so Jaksi, still waiting for the judgment.
Yes, I wanted to say thank you to Team One. It was really a pleasure to meet you. I can say that you're a very worthy opponent. Maybe you can share your Instagram accounts or maybe other social networks so we can keep in touch further.
Yeah, I would love to share that. So we'll share it to the chat box. Is that fine?
Yeah, that's good.
You can use this Zoom chat box to exchange contact details. Feel free.
So you're still here waiting for us. Great. Okay, Philip and Case will join and will deliver.
We were learning some basic Kazakh and basic Hindu sayings and expressions. Yeah.
I see. Oh, we've got Instagram account Team One. Is it your like whose exactly Instagram account it is?
I would say the first one would be mine.
I see.
Yeah, so the entire team has shared it as we decided to connect
Okay.
to know each other in person rather, as this was
All right.
Yeah, we
Is
decided.
there something interesting? Should we check? Okay. I'll take it as yes. Case, where are you? Rustam, maybe you can help Case to.
I will send.
Thank you.
The link.
Hold my beer. Okay.
Hold my beer.
Don't pay attention to my Instagram account. It is the name of my Instagram account, and it has nothing to do with beer. I'm sorry.
Oh, beer. Okay. Amina. Philip, do you have an Instagram account?
Not really.
Okay.
I'm not very much into social media. We use WhatsApp within the family. We do a little bit of social media, but I'm afraid I don't know how old-fashioned I am actually, but I like emails. I like that you can actually keep an email and there. Here's Case.
Yes, Case here. So, okay, we are ready to deliver our judgment. Prior to that, we'll share some comments, which will then be translated into the judgment, right? So, Philip.
Okay. Well, first of all, thank you very, very much indeed to both teams. You've put in a great deal of work onto this, both in terms of the written memoranda and in terms of your presentations. You've coordinated between members of the team. You've been put on the spot with questions being fired at you by each other's team and by the judges, and you've stood up to the pressure that puts upon both of your teams there. We have, in a sense, two functions to fulfill. We have the function of deciding who is the ultimate winner between the two teams, and that's the issue that you're probably all really waiting for. Also, in a sense, I think maybe having worked a lot on it, you might like to understand what our views are on the outcome of episode 1 and episode 2, where we haven't really formulated a final view, but we'll give you an indication of what our thinking is on episode 1 and episode 2. Now, which way should we do this? I'm inclined to keep you in suspense a little bit as to which of the teams won, because if I tell you which of the two teams won at the beginning, you won't be really interested in what we say about the two outcomes. So let me then instead say a little bit about episode 1 and episode 2 and the possible outcomes there. Both of them are very interesting issues there, and quite difficult issues to deal with. In a sense, in episode 1, what we have is a circumstance where a bank has clearly provided financial support, but under Islamic finance, it's in the form of a murabaha contract, specifically in order not to generate riba, not to generate interest. But on the other hand, there is clearly a financial reward being received by a bank, and that looks very much like interest. In a sense, any of these contracts under Islamic finance are all designed to generate, in effect, a financial reward, but in the form of a business partnership or an increase in the sale of products. How far should a structure designed to avoid interest under Islamic law be recognized under international law as interest or not interest? My own inclination on this is to say that there is a financial reward here, and without being offensive to Sharia, it is interest in terms of international treatment, and therefore it is appropriate to treat it as interest. But we then have the subject to tax rule, and the bank is exempt from tax. I raised the question as to whether the bank was liable to tax at all. I mean, we have an interesting question here as to whether the bank was even a resident of what is it, tax haven land, given that it's not liable to tax. But actually the answer came back very well, but it is liable to other taxes. It's not there in the facts, but you're perfectly entitled to make that up and tell me that. Assuming it is a resident, it's clearly not subject to tax. And so if it were a matter of deciding that point, my inclination would have been to say that a 9% withholding tax was appropriate. The argument about a permanent establishment, I'm afraid I think that never really got off the ground, because it's very clear that having a subsidiary in another country does not give rise to a permanent establishment unless either the premises of the subsidiary are at the disposal of the parent, or the subsidiary acts as a dependent agent permanent establishment, and there was no factual basis for alleging that here. So on the first of the episodes, as a matter of law, I would have been inclined to say that the 9% withholding tax was actually correct. I'll perhaps give my views on the second point, and then I'll stop for Professor Van Raad or others to comment on the legal issues, and then we'll come to the key question of who's won. The second issue is also a very, very interesting question, where you have a board of directors, but we are told that that board of directors effectively take all their instructions from an AI-based system of software operating out of the other country. Now, when we start with domestic law, sorry, I have difficulty with the names of the countries, but tax, what's it called?
Tax Paradise
Land. Tax Paradise Land treats the company as a resident by virtue of incorporation. That's a perfectly normal type approach. Salikland treats it as resident under domestic law because it considers that the operation of AI from that country gives you management and control. That's a matter of domestic law, that's taken. We are not looking at the domestic law. But that leads us then into Article 4.3 and the tiebreaker rule, and that's a question of the place of effective management. And when we're determining place of effective management, we're looking at international tax law. We're not looking at the domestic law of the two countries. The domestic law gets us into a situation of dual residence. We are then looking at international tax, what is meant by the place of effective management. And on that particular point, I have to say that I find it quite difficult to consider that the jurisdiction where humans are located, but those humans are taking their instructions, even if they're taking instructions from a machine, I find it hard to see that that as being the place of effective management. But I recognize that that is a very, very open issue. It's just a preliminary view that I find it hard to see that as the place of effective management. The consequence would be that it ought to be the place where the AI is, the place of effective management. One thing I would say, and that is that not agreeing to go to MAP in those circumstances, there is a view that where you have a tiebreaker under the place of effective management, the two contracting states have an obligation to resolve it and therefore have an obligation to go to mutual agreement procedure and to resolve that question. So to deny MAP in those circumstances seems to me to be contrary to the treaty. Before I come on to the really important question about who won, shall I pause there and see whether on the legal issues of the two cases, whether Professor Van Raad or Mr. Kesselgoff would like to add anything at all?
Professor?
Well, there's very few things. I was, I received the case only a few days ago, and I think I would have loved to spend more time, and I will probably spend, after today, more time on this particular case, because there were quite a few issues that were not sort of at the core of our discussion, which do raise, very interesting international tax law. So one thing I thought of, what if the AI company had its board of directors in the other country, and the board was acting like, like they were doing in this case, just performing whatever they were told by the AI. So we addressed the question of whether that may amount to a place of effective management. Another interesting question would be, if indeed there would be, if they would operate in another country, if that could give rise to a permanent establishment. I mean, can you say when people are simply there and acting like robots, obeying the orders from the AI, is that, even when they're sitting, somewhere and doing that, is there any function, any function performed there that would attract any profits? So even if it would be a physical PE, there would probably no profit whatsoever being attributed to that. That's just a thing that crossed my mind. In general, I would say that I was very impressed, both with the preparatory work, the written work done by the two teams, and I would say if students of mine would perform at about half the level and the capacity that you show, they will be doing very well. So I really want to compliment you with all your preparatory work and the way you performed today. So let me give the microphone to Raviv.
Thank you. Couple of comments from me, but no legal analysis. That was enough from Philip and case. Well, it was a great pleasure to actually judge this game, and the battle was so unbalanced for me. If we check the memos, for me, there is a clear winner, although there are factual mistakes, very important mistakes. Then answering questions, there is also a clear winner for me. Teamwork, also unbalanced. I think that one team did better than the other. And if we go through these criteria, every time, at least for me, every time there is a very unbalanced result, there is a clear winner. But in total, the points are so close. I mean, if we just go to calculation, we will probably have a 1 point difference between two teams. So enough said. Philip, please deliver the judgment.
Fine. Well, I'll come back then to the issue there. Firstly, let me concur with both Case and Ravil there. Both teams put a lot of effort in there. In terms of the written memoranda, we were looking both at the written memoranda and at the oral presentation. In terms of the written memoranda, the Indian team's memoranda, I think, was very clearly structured and perhaps presented the points and the legal authorities rather better. But there are two particular points about it. One of them is this focus on the element of a permanent establishment, which really was not an issue that could have got off the ground. The second one was this confusion about whether or not you were saying there was or was not interest in the circumstances. You confirmed that there was a typographical error. You can't do that in an arbitration and say to an arbitrator, there was we had a not when we should have, when we meant that when the not should not have been there. The Kazakh team memorandum, I think you needed to explain more clearly why you were using Kazakh domestic law and Russian domestic law. This was not a treaty between Kazakhstan or Russia, and I don't think I'm not saying that it's inappropriate to make reference, but I think you should have identified the status of that there. But they were interesting memoranda there, but I think India's memorandum was probably the better constructed of the two. In terms of oral presentations, particularly the way in which you worked as a team together and the way that you answered questions, then I would have to say that the Kazakh team was better in terms of their interplay between them. I'm sorry for the three members of Team 1 who were sitting behind and who didn't get a chance to speak, and probably you were sitting there and thinking, oh, we'd love to participate as well. Putting that all together, it really is very, very close between the two teams, but we have to award it to the Kazakh team, to Team 58. There, we think that on a balance, they have slightly better overall marks, and it literally is. I added up my marks that I gave it, and there was 1 mark in it. So Indian team, you should not in any way get to go away from this and be well, you'll be disappointed, but you shouldn't be sort of too self-critical, because it was very, very close between the two teams. But in terms of answering questions and working as a team, we think that Team 58 is the one that wins overall. So congratulations to both teams, particular congratulations to Team 58.
Congratulations, guys. Indian team, you are great. Kazakh team, well, you did not disappoint. It was a very close game.
Good. Well, thank you very much indeed, everybody there, and thank you for the opportunity to do this. And let's step back a second. Actually, I have to tell you, it is incredibly difficult arguing cases and litigation. I've spent part of my life litigating, and you prepare for a case and you think, the one question I really don't want them to ask is this, because I don't really have an answer to that question. And you stand up and the judge says, Mr. Baker, may I just ask you this question? And you think, It's exactly the question that I did not want to have to answer there. But you have to, you've got to do the best for your client and put forward the best answer you can. And I think that this was a good experience. In 50 years' time, when you are arguing your last tax arbitration case, think back to this as your first experience of doing an online tax arbitration dispute. But thank you very much indeed to both teams and to everybody who put this the moot together.
Thank you so much, Philip. Thank you so much, Case, for spending your extremely valuable time to help with your expertise, with insights, to basically continue educating for all these years. I used to be also like 20 plus years student at a certain point in time, but time flies so far. I invited a couple of graduates from ITC Leiden, but since we slightly behind the schedule, they had to go for another meetings. But we had here Andrei Kudyarov, country manager of Kazakhstan and Caspian region of Shell, willing to deliver his comments, and Erki Ustalo, interim tax director of Bolt, which is basically great aggregator. I'm also grateful to Zaid Maniar, managing partner of Emirati consultancy firm of Indian origin. So reason why I invited Zaid to express his comments and in a way to support Indian team because of the common background. I know that Zaid also is coming from India. And Zaid, if you could give your comments and encourage the young participants to pursue the education and career in the field of international tax briefly, it will be very much appreciated.
Thank you, Rustam, and sorry to be a bit late to the party. We were actually hosting our own firm's Pillar 2 event today, and the Middle East is an active player and supporting the OECD with these regulations, especially since Pillar 2 has come into effect from January the 1st. Seeing all these young faces around, I think Phil sticks out the most. His energy, his vibrancy, it shows you that the profession is ever evolving and we're always eager to learn. So if there's anything that you learned today, friends, it was about healthy competition. Many of you, as you develop, will go into different organizations. You may end up, even though as friends, on either side of the fence. Now, in this game of life, there's only one winner, and that's the truth. So wherever you're working, whatever you're doing, remember, truth always prevails, and be an ambassador for it. Why are all these regulations coming in? Countries need taxation. Why do they need it? They need it to educate young people. They need to keep old people like us going and our needs going well. So all that requires funding. Funding comes from taxation for the most part, and it's important people, companies, multinationals follow these to the best of their ability. So with that note, friends, thank you, and thank you to the esteemed panelists for taking their time. Rustam, I always like your energy. My friend, I appreciate you making this initiative. And of course, if ever anybody's in Dubai, please do drop by, visit us. If you're on holiday, we'll grab a coffee or lunch. It's our pleasure. Thank you. Thank you.
We will come with the whole team to have the next edition of JurAsia InterTax in Dubai next year.
Welcome, welcome, welcome. We recently hosted a large group of MBA students from Switzerland about how organizations are evolving in light of new taxes. So for the Middle East, corporate tax is something relatively new. So yeah, everybody is welcome. And Rustam, you know where to find me.
Okay. Thank you very much. Thank you very much, Zaid. And this was in particular to address the Indian team endeavors and efforts. So that was the purpose of this brief intervention. Case, would you like to add anything? Because we're all grateful to you. Well, at least I myself, being Leiden graduate, learned quite a lot and progressed quite a lot from the level of maybe not as smart as the current team presenting their cases, but well, somewhere around this too. Well, much better educated person over the years. I know that you're still running your courses, and I'm not the only lucky one who can learn from education of ITC Leiden still offering its trainings. So thank you so much again, Case. And I would think it would be fair to give you the concluding words, concluding remarks on this game, considering that you have time limitation. I remember about this. So
sure. Well, thank you, Rustam, so much, and thank you also for having, in addition to yourself, did two other alumni. You know, I saw them. I wasn't able to communicate with them, but I will later today. You know, contact them. I'm enormously grateful for the opportunity that I had to be a judge today. I've been a sort of professional judge on a part-time basis in Holland for many years, and what I really enjoy in all those 15 years that I was a part-time judge, and also enjoyed again today, that as a judge you can learn a lot yourself from the particular case that's being presented, from the arguments, even when they are incorrect. You know, it helps you to understand better the underlying issues. And I'm enormously grateful to you, Rustam, for, after you graduated from the ITC many years ago, to have developed this activity, giving young people the opportunity to, get a lot of background in international tax law, to join a opportunity like today, to present themselves. I'm enormously grateful to you, Rustam. So let me conclude with that. Thank you.
Thank you very much. Thank you. Very much appreciated. I think it's a common contribution, common effort, and common success. I believe we all benefited a lot from helping each other and joining basically our efforts and knowledge and expertise. So okay. By this, we will conclude this round, and this is not the end. This is just beginning of the, let's say, next year edition of this JurAsia Tax initiative. Perfect. Thank you to Ravil as well for supporting this with his help, with his staff, with his time and efforts. Lots of thanks had been said to me, to professors, but Ravil was maybe not as visible as the others, but not less valuable, not less important for the success of the whole this event and the whole this venture.
So thank you everyone.
Okay. Bye now.
Bye.
Thank you very much. But sorry, I have a last question. Was it final round or we have a further competition?
That was final round. Yeah.
Okay. Thank you so much.
Yeah, first place Kazakh team, second place Indian team.
Okay, good. Thanks.
You'll get your prizes. Okay, thank you everyone.